Good morning or afternoon, depending on when you're watching our workshop. My name is Jen Crane, and I am an attorney with Odin, Feldman, and Pittleman in Reston, Virginia. I'm delighted to have this opportunity to speak with you today regarding tools in our capacity toolkit. I'd like to thank Jan Russell and the ARC of Prince William for having me here to talk about such an important topic. The reason I wanted to speak on this today is I find there is a tremendous amount of misunderstanding regarding capacity and special needs individuals. I've practiced in this area for 17 years. I'm a mother of 5, and one of my children is medically complex. He was born with a cleft palate, deaf, heart and kidney disease. The reason I share that with all the families that I have the privilege of working with is I feel it's important to underline, to stress just how difficult it is to sit on this parenting side of the table. So my job is to empower you with tools to help understand what we legally can and cannot do. My trajectory was a little bit different. I was a special needs attorney before I was a special needs mom. But I found that having all of that background was invaluable in allowing me to advocate for Joe. That's why I want to talk about this today to make sure all parents have these tools to advocate. So let's talk about capacity and what that word means. Capacity is the ability, and my goal today is to speak without any legalese, just to speak in normal, everyday terms to make sure this topic is understandable. When we talk about capacity, we're talking about the ability to understand the actions we are embarking on. Now, capacity really comes into play when our children start sidling up to their 18th birthday. That's the date at which legally, 18, they become an adult, and we lose the ability to make decisions for them based on the law alone. Once they are no longer treated as a minor child, the law considers them to be their own adult. Now, I think as most parents of any 18-year-old would say, they're not mature enough to make those decisions. But when we're sidling up to that age and we have the factor of special needs at play, we want to talk about decision making. Now, one of the most common misconceptions in this field, and frankly, one thing that drives me absolutely batty, is the misconception that if an individual has special needs, they automatically need guardianship. That's not necessarily the case. Let's take a moment and talk about these two very different tools we can use to accomplish the same goal, making sure our loved one with special needs is empowered to make decisions regarding their self, their care, to the extent they are able to do so, and us having the legal authority we need to be able to continue advocating for them. The first tool we're going to talk about are powers of attorney. Now, powers of attorney, you've heard about them. Some of you probably have them. No one really thinks about them in the context of an 18-year-old. But I tell all my clients, neurotypical, neurodivergent children, doesn't matter. At age 18, we need to consider powers of attorney. Your child is heading off to college. You want to be able to have access to assist them, say with matters involving tuition payment, making sure bank accounts have enough money to pay cell phone bills, all of that type of everyday thing that we've always done for our kids. Once they turn 18, we need some legal authority to assist us in that process. So a power of attorney is one avenue we can explore. Let's talk about what a power of attorney is. Power of attorney is a legally binding document where the principal, the person signing it, gives to the agent, the person named, the authority to stand in the principal's shoes and act for them. To stand in the principal's shoes and act for them. Now, what's crucial to understand about a power of attorney is that it is not a blank check to do whatever you want on behalf of the principal if you are the agent. Although that power of attorney gives the agent sweeping powers, The agent has what's called a fiduciary duty to act in the best interest of the principal. That authority flows from the principal to the agent with the implicit understanding that that agent will only make decisions that are in the principal's best interest. So, even though this document allows basically anything to be done on behalf of the principal, the agent has a duty to act in the principal's best interest. So, how do we get a power of attorney? Well, you can go to a lawyer like myself. You can print these off online. Not that I recommend doing that, because powers of attorney, as I just mentioned, are powerful, powerful documents. And in order to execute one, to sign one in conformity with the requirements of Virginia law, you want to make sure that the individual, the principal, granting the authority to the agent has the requisite capacity. See, you knew I was going to bring it back to talk about the tools in our capacity toolkit. We want to make sure they have capacity. Capacity is the ability to understand what they're signing, very simply put. When we talk about powers of attorney, the standard of capacity is pretty high. It's the same capacity required for an individual to enter into a contract. Now, it's Virginia. I like to joke, we're a commonwealth, we're not a state. We keep things as complicated as possible. You have to have a requisite level of capacity to execute any legal document, whether it's a financial power of attorney, a medical power of attorney, a deed, a trust, a will. And unfortunately, we don't have one standard that applies to all of them. But that standard for the financial power of attorney, the ability to contract, is frankly the highest. The analogy I give folks, you would have to be able to walk into a car dealership, buy a car without being taken advantage of. Does that mean you have to understand every sentence of every subsection of every article? No. It just means you have to understand this authority that you're granting to your agent. Now, I mentioned to you this common misconception that special needs individuals automatically need guardianship. And unfortunately, it's one we still battle today. I'm very grateful for organizations like the ARC that offer this educational programming to teach families about their options. If no one tells you what your options are, you won't know. So we want to explore whether powers of attorney can be utilized. If a child, an 18-year-old, can come to me and say, Jen, I need mom and dad to keep helping me. Here are the things I need them to help me with. If we can have a conversation at that level, I'm confident with the power of attorney. And it's really important to have a lawyer do that capacity assessment. And here's why. Powers of attorney, as some of you have probably already encountered, are universally difficult to get accepted. Banks and financial institutions simply do not want to take them. Why? They're worried about fraud. They're worried about somebody taking what I affectionately call a bum power of attorney, one that's been replaced. It's no good, but the bank doesn't know it's been revoked. The bank's worried about somebody coming in with an old power of attorney, a revoked power of attorney, a fraudulent power of attorney, and seeking to take action on behalf of an individual who they then are concerned will turn around and sue the bank for accepting this bad power of attorney. Because these documents are so difficult to get accepted, and it's not an exaggeration to say I spent 15% of my career fighting with financial institutions to get these documents accepted. Because this battle we know is going to be forthcoming, having a lawyer do the document gives you a couple legs up, because now you have the authority to engage in battle with somebody who can assist you. And from my vantage point, forgive the reference, I'm Italian. If I'm going to go to the mattresses with the power of attorney, I need to have drafted it, and I need to make sure a couple boxes are ticked. I need to have met with the person, the client, your child, myself. And I just want to offer, these are all, this entire workshop today is offered as an overview, a presentation to give some basic information. There's, no obligation to move forward with anything. This does not create an attorney-client relationship between myself, anybody who's listening. The purpose of this webinar is educational only. And if you had any doubts that I'm a lawyer, you've got proof now because I just gave you a disclaimer. Stepping back, I want to have met with the client. I want to have assessed capacity myself. And in certain instances, I'm going to ask for a doctor evaluation, stating the individual has capacity. Here's why. Legal capacity and medical capacity are two different things. You'll remember I told you that Virginia's Commonwealth, we have our own way of doing things. This is one of them. I want to make sure that a medical provider who knows your child, knows that special needs individual's diagnosis, and can opine on their ability in a much more in-depth way has had the opportunity to do that. Why? Because when I'm fighting with the bank to get that power of attorney accepted, it's another arrow in my quiver. I have a capacity evaluation from my client's treating physician stating they have the capacity to understand what they signed. That's a really, really important step. A lot of folks don't take that step, attorneys alike, and a lot of folks are going to be tempted to run out of power of attorney that they find online and execute that. But if the power of attorney doesn't have all these requisite components, there's never a guarantee these documents are going to be accepted. Just because we have a power of attorney doesn't mean someone has to take it. So we need to put that power of attorney in the best possible light to be accepted. Have it drafted by a lawyer so you know it's in conformity with the Uniform Power of Attorney Act. Virginia passed it quite some time ago. It's been over a decade. But the purpose of that act was to ensure uniformity. We want powers of attorney to look alike so banks and financial institutions have comfort in taking them. We want that uniformity. We want those individual evaluations to make sure the client understands what they're signing. It's a really important distinction, and we're going to talk about guardianship for our second half, which is an important tool in the toolkit as well, but it's not one we automatically want to jump to. However, even though powers of attorney they're definitely an easier route, cheaper route, don't require court action, we still have to dot our I's and cross our T's. Make sure the client knows what they're signing. Make sure the power of attorney itself is in conformity with the requirements of Virginia law, making sure it's executed properly. What do I mean by that? We have rules for how a document needs to be signed to be valid. And that's the case for any legal document in Virginia. And frankly, I'm not barred in all 50 states, but I have to imagine it's a requirement in all 50 states. We have to make sure that that document is signed by the principal in a way that their signature can be verified. It's got to be signed at least in front of a notary public. I put 2 witnesses in the room as well. I want that document to scream from the rooftops. It's valid. Executed in conformity with Virginia law. The principal had the capacity to understand what they were doing, to understand the power they were giving to their agent. I am confident in all of those things because I've got a doctor evaluation helping me, backing me up in what I feel is an appropriate choice. And then that document is executed appropriately with all the powers our agent needs to act. The really important thing that a lot of folks don't consider when running down the power of attorney, Pike Avenue, pick a word, when they're running down to get that done, what I'm thinking about, I need all the authorities in that power of attorney to hang my hat on to make sure the power is there for the agent to act on behalf of the principal. When Big Bad Bank, Big Box Bank, refuses this document, let's say all of our other boxes are ticked. It's not too old. They've accepted that the individual has capacity. What if they say, well, wait a minute, I don't know that the agent has the authority to do this, because a lot of prefabbed power of attorney forms will just have a blanket, my agent can do anything I can do. That's not going to cut it. We need to have the individual authorities listed so I can say box bank, bank box, big bank. Here's the authority required for my agent or for the agent of this principal to act on their behalf. Now, you heard me say when we're going through this little checklist, power of attorney is not too old. What do I mean by that? Well, legal documents, powers of attorney, don't expire. They never go bad. It's not like a yogurt that it's going to be past its expiration date. But one of the most common reasons banks will kick a power of attorney, refuse to accept it, is they say it's stale. Now, stale is not a legal term. It's a term that the industry has coined to say it's old. And in their opinion, a person would have already executed a new one. They would not have let this power of attorney hang out this long without doing a new one. Now, I'll tell you as an aside, if everybody updated their powers of attorney as frequently as banks seem to think they do, I would be rolling in dough. It doesn't happen. But when powers of attorney have been hanging out for too long, that's where the concern lies. Every 3 to 5 years, those powers of attorney need to have a new date on them. Go back to the lawyer. Lawyers, if hypothetically speaking, this is how the conversation runs in my office. Everything the same, no major life events, come back on in. We're going to rerun that power of attorney with a fresh date. It's the first hurdle we want to clear. I always tell folks the Constitution promises us as citizens, valid where executed, valid everywhere. But do you want to pay me to fight with a bank or pay any lawyer to fight with a bank about the Constitution? Or do you just want to execute a new one? Sometimes this is the path of least resistance. How can we get this to where it needs to be? We want to make sure that date is current or as current as possible. I don't recommend going any longer than 3 to 5 years between updates for that power of attorney. So we've talked about the financial power of attorney, the requirements that we have to execute it, and to make sure we're aware that it is a possibility for our individuals with special needs. We don't automatically have to jump to guardianship. We've got the financial power of attorney, but then there's another component, that's the medical component. We want to make sure that there is a medical decision maker appointed for all of those personal decisions that our individual may need to make. We've got those two documents that work in conformity with one another. With the medical power of attorney, you're going to encounter a lot less resistance in having it accepted. I give my clients my cell phone number so they can call me in the event of emergencies. In 17 years, I've never had somebody call me on a weekend or at night because the medical power of attorney won't be accepted. It's kind of a sad commentary if you think about it, because the medical power of attorney is just as important, frankly, more important if we're making decisions about somebody's care. It doesn't receive the same level of attention or the same level of scrutiny, but it is important nonetheless. The financial power of attorney allows the agent to do everything that is not medical on behalf of their principal. The medical power of attorney, all personal care decisions. Now, there's different components to a medical power of attorney. I want to talk about that for a second. Attorneys can choose to draft these in very different ways. My examples are all based on my practice and what I've done. I've always done one document for my medical. You're going to hear me say healthcare power of attorney, medical power of attorney, advanced medical directive. For our purposes today, I want you to think of that as one document. That one document, or your medical planning, if you go to an attorney who chooses to break it up, needs to have several components. We need a document that appoints somebody to make decisions. It's that same concept of principal to agent. I, as the principal, grant the authority to make medical decisions to my agent. Then we need to give that agent powers. We have to delineate what the agent is allowed to do on behalf of the principal. Then we need to have that very, very important component of the living will. Now, I want to take a moment and clarify that living will is separate. Our medical power of attorney construct is separate from a DNR. A DNR, as some of you are probably familiar, is a do not resuscitate order. That's something only a doctor can do for you. A legal provider can't. Do not resuscitate order is something you speak to, generally it's a PCP, somebody who's involved in every aspect of your medical conditions and care, to say, if I am found unresponsive, I do not want to be revived. It's a notice your doctor signs. It would either be posted behind the front door or on the refrigerator in your home to give the paramedics that heads up. If you're found not breathing, don't start life support. But a do not resuscitate order is not a component of a medical power of attorney. It is a component of medical care, but it's not something that a lawyer will do for you. I'm going to pull us back on track after I took that little side route. Your medical planning, you have your document that appoints agents and gives them authorities to act on your behalf. Then we have the living will. The living will is the part that says, don't keep me alive in the event that I'm dying. But it's really important. This is what, when we have somebody executing a medical power of attorney, this is the piece I have to be 100% confident they understand, because we're giving the agent the authority to stop or withdraw life-sustaining measures. To stop or withdraw life-sustaining measures. And that's why I say we don't give this medical component merely its due, because it's crucial. It's crucially important that the individual signing the document understands this. Now, it's not all or nothing. You don't have to say your child, as they're investigating what they want for their care, doesn't have to say, I want every life-sustaining measure. I want no life-sustaining measures. It's a conversation we have to find what they're most comfortable with. As we advance in life, the typical response is to say, I don't want anything, let me go. But when you're younger, you want everything under the sun. Your power of attorney can reflect that. And this is why it's so important to work with a lawyer to execute these documents and not pull a prefabbed form, because a lot of those forms are automatically going to default to, I don't want anything, when that's not necessarily what we need. We can walk through what you want, what treatments you do or don't want, how long you want life-sustaining measures. But that's all part of the capacity discussion with the client, making sure they understand what authority they're giving to the agent. We need to make sure, as we're talking about our medical component, there's a HIPAA authorization. We all know what HIPAA is. It's driven us crazy at some point. It's a federal statute with a very noble purpose to make sure our confidential health information is protected. But if the agent doesn't have the authority to gain access to that medical information, it's hard to make decisions. We can't make decisions for somebody else in a vacuum. We have to make decisions with all of the information at our fingertips. So you want to make sure the medical planning encompasses a HIPAA authorization. Now, from my own personal practice point, I do all of this in one document. Why? Stress and grief do not do good things to us. I lost my dad in 2015, and you would think that I had never practiced in this field. I couldn't find my way out of a paper bag. Why? Because stress and grief do not do good things to us. So if there is a moment where the agent that we serve in our fiduciary duty under a financial or a medical power of attorney is being taken by ambulance to the hospital, and we get the phone call, what do you want to do? I don't want to be diving through a thick binder trying to find these documents. I want it to be very clear. I need just this one, and here it is. Now that again is just something I've instituted in my practice. Doesn't mean it's right or wrong. It's just what I've come to as the most prudent way to manage on behalf of another person in those times of grief and stress. So we take our 2 steps back and we look at the documents we've got. We've got our financial power of attorney and our medical power of attorney that allows us to stand in the shoes of the principal we serve as an agent to make decisions. These are the documents that empower us with legal authority after our loved one has turned 18 and we have no other way to make decisions for them. Now you're going to say, but Jen, when I go to the doctor, they let me come in with my child. That's great. Some doctors will, some doctors won't. Some doctors will accept that verbal authorization to be in the room, but these powers of attorney do so much more than just allow somebody to be in the room. They allow you to be a decision maker for your child as you were before your child turned 18. But in order for you to be that decision maker, we have to make sure they have the requisite capacity to enter into these documents. Again, they don't have to understand every single word. In fact, I'm sure there's phrases in there that adults who've had exposure to contracts for years won't understand. But what they do have to do is understand they're giving this power, and it is a power to somebody else to make decisions for them. Now, one thing I do recommend for that medical power of attorney, and it's hard, as we talked about that decision whether or not to include a living will, whether or not to include how we include that information. Do I want to be placed on a ventilator? Do I not want a vent? Do I want a G-tube? Do I want feeding assistance? Have that conversation with your agent. It's hard. None of us want to ever think about that happening, but we need to know what those we serve want. You know, for my neurotypical clients who come in, I always recommend they write a letter to their agent, letting them know what they do or do not want. And I tell folks to think of it as a permission slip, non-legally binding permission slip that gives that agent some idea, some comfort. Because when the time comes that we step into shoes to serve someone else, we need to be confident we're doing what that person wanted done. We can't ever do what we want to do. That's a breach of our fiduciary duty. When serving our principal, we have to do what our principal wanted done. So I can't encourage folks enough to have those difficult conversations. Make sure you know what your loved one wants so that you can effectuate their wishes. Okay, so we've talked about the tools we have in our capacity toolkit. There's wills as well, but I'm not going to talk about that today. When Jan and I first started discussing this series that we were going to put together, the topics are endless. I'm barely scratching the surface of things I want you to know. But for right now, this was the most important thing I chose to focus on. The tools in our capacity toolkit, our powers of attorney, our ability to stand in the shoes of another individual and serve them, assuming that individual understood this obligation, understood the powers that were being granted, wanted to grant them. The important thing about powers of attorney is they can be revoked. They're not permanent. You heard me talking about making sure they're not stale. We also have to make sure they're in effect. That's that big bank's fear. Power of attorney's been revoked. Somebody is offering an old power of attorney. It is no good to act on behalf of an agent who no longer wants them to serve. Powers of attorney can be revoked. Virginia gives us a whole bunch of ways we can do it. It can be as simple as tearing that document apart. So when we talk about having an agent, when we talk about that principal making us their agent, we have to understand that that's a choice. It does not circumvent, it does not supplant the principal's ability to make their own decisions. If my husband is my agent under power of attorney, it doesn't preclude me from doing any ding dang thing that I want. I still maintain my own authority, my own agency to make my own decisions. But if I give my husband this authority to act on my behalf, it means he can help me, doesn't take away what I have. And that's a really important distinction because it's not just capacity we want to ensure our individual has. When we're talking about how to best serve our new adult with special needs, there's a lot of factors to consider. Is this permissive document? Is this permissive financial power of attorney or medical power of attorney? Is it enough? What do I mean by that? When I say permissive, I mean giving permission to. I give someone permission to act on my behalf. doesn't stop me from acting. And it matters because if our special needs individual is particularly vulnerable to being taken advantage of, powers of attorney may not be your best route because it doesn't offer us the same protections guardianship and conservatorship do. I'm going to come at the very end of our time together, come back to these differences, how we decide which is the best avenue to pursue. It's important to me that families know powers of attorney are an option. They're not always the best option, but they do need to be explored. So now that you understand a little bit of the backstory, let's flip to guardianship and conservatorship, which is frankly what most individuals are familiar with in the context of decision-making for somebody with special needs. Guardianship and conservatorship, because remember, it's Virginia, we're going to make this complicated, are the process of petitioning, going in front of the local circuit court for the county where you live, and asking a judge to declare someone legally incapacitated to make medical and/or financial decisions. Let's talk about that process for a second, because it is neither quick nor easy. There is a tendency to think of guardianship and conservatorship as rubber-stamped proceedings. Automatically get it when somebody turns 18, you get a lawyer, you go to court, done. It's a huge thing. When we go in front of that judge, of that man or woman in a black robe sitting on the bench, we're asking them to declare an individual legally incapacitated. When we define legal incapacity, the easiest way to understand it is I am removing someone's rights, all of them, and I'm effectively making them a child again. For purposes of the law, they are a minor. Their guardian is the person who has the authority to make all of their decisions. It's a big deal. And unfortunately, it's not given the weight and the sensitivity that it should. You know, one of the most moving moments of my career, I was a new lawyer. It was 2007, guardianship and conservatorship. And again, we're going to talk about those differences in just one moment. Proceeding for a young woman who had just turned 18 with a Down syndrome diagnosis. We're getting ready to go in front of the judge, and the case had a couple of hiccups because it was brought by a lawyer who doesn't routinely practice in this area. And I was the guardian ad litem, term I'm going to define in a moment. The petitioner, mom and dad, grabbed me by my suit jacket and said, "Are we doing the right thing?" They got it. They got what a big deal this was. We are removing somebody's capacity. We are giving them a new decision maker. Let's talk about what this process looks like. You file a petition with the circuit court alleging, because these are adversarial proceedings. What do I mean by that? It used to be, and I can't believe I'm old enough to keep saying it used to be, back in my day, but here we are. It used to be that these petitions were mom and dad, assuming it's parents bringing them, versus child, like a lawsuit. Same way it would be in a divorce proceeding, any litigation. Because guardianship and conservatorship is technically litigation. The courts have since changed that, so it says in re, but it's still an adversarial proceeding. Mom and dad are, if it's again the parents, I'm just using that for purposes of our example. Mom and dad are alleging to the circuit court that child is incapacitated and needs a legal decision maker. We filed our petition with the circuit court. In addition to that petition, we have also filed a doctor's evaluation. Remember that from when we talked about powers of attorney? It's a doctor's evaluation where the doctor alleges, or the doctor states for the record, it's evidence that comes in. This person is incapacitated by virtue of their diagnosis. Now, it's important to note a lot of practitioners, myself included, use different capacity evaluations for powers of attorney versus guardianship. My capacity for powers of attorney form, it's easier, it's quicker, it's only 2 pages. My capacity evaluation for a guardianship and or conservatorship proceeding is far weightier because it tracks everything in the statute about what needs to be there for the court to aid the court in making its determination of legal incapacity. So we've got our doctor's evaluation that has to be filed with the petition before it can move forward. So if you go to a lawyer and they tell you they need this capacity evaluation, we need the capacity evaluation. We have to have it for this proceeding to move forward. Once the guardianship and/or conservatorship is filed, and I'm going to define those two terms in a second. First, I want to give you the overarching viewpoint. A guardian ad litem is appointed. Guardian ad litem's role differs state to state, so this is just for purposes of Virginia. That guardian ad litem is a lawyer who has special training in how to serve as the eyes and ears of the court. They are not the individual's attorneys. So in this adversarial proceeding, the individual with special needs is called the respondent. They are the person who responds to the allegation that they are legally incapacitated. This guardian ad litem is the eyes and ears of the court, and that guardian ad litem reports back to the court on whether or not this person does in fact need a guardian and/or conservator, and whether or not the proposed guardians, are an appropriate choice. It's not the respondent's attorney. Now, we recently had a lot of changes in the guardianship and conservatorship statute. If an individual says they want their own lawyer, the court's most likely going to get them one. And at that point, we are moving from uncontested to potentially contested. What do I mean by that? Again, this is litigation. If it is uncontested litigation, if no one is fighting what needs to happen, uncontested, the guardianship moves forward. We have a hearing. If you're in Fairfax County, Prince William County, whatever day of the week that court holds those hearings, it's usually a 10-minute proceeding. Everybody should appear in front of the judge because these are important. Lawyer, guardian ad litem, petitioners who brought it. I always encourage the respondent to attend if they can, as long as it's not going to be upsetting for them. There's no statutory requirement that they be there. But because this so intimately involves them, I do feel it's important for them to be there. Again, if it won't be upsetting. This group appears in front of a judge. The judge grants or denies the petition. If it's granted, the family then goes to the probate court. Well, the probate division, a division of the court to actually get their certification paperwork, that certificate of qualification. It's a one-pager with the seal of the state, seal of the court that says mom and dad, they were the petitioners, are now the guardians and/or conservators for their child. As part of that appointment in the probate office, the probate clerk will walk through what the requirements are, the reporting requirements for the guardian and the conservator. I promise I'm going to define those. I'm going to finish walking through the procedure first. The court has appointed individuals to make decisions. The court has to make sure those individuals continue to act in the best interest of their special needs person, of their ward. It's no longer the respondent petition, the proceedings ended. We have to make sure they're acting in their best interest. We do that with reporting requirements, guardianship reports saying how the person is doing. And then if it's a conservatorship, reporting to the Commissioner of Accounts. I'm going to talk about that a little bit later. When we have a guardianship and conservatorship and/or, because you can't have them bifurcated. It's not a necessity to have both. And I'll talk about that, I promise. When we have guardianship and conservatorship, the person's legally incapacitated. We've taken away their rights. They cannot enter into a contract. They cannot potentially vote, carry a firearm, marry. All of these are things that are supposed to be listed in the petition. Now, it used to be, see, there it is again. When I first started practicing, regardless of the level of incapacity, we left the right to vote because it's not something that everybody had for a long time. There has been a trend that if a person is incapacitated, they are incapacitated, and we can't necessarily pick and choose cafeteria style which rights they keep. So there's a trend that it's all or nothing, which is again why I need to make sure powers of attorney are not an option. When we have guardianship and conservatorship and a judge has declared an individual legally incapacitated, should that person be taken advantage of, be prone, be vulnerable to people trying to take them for a ride. Guardianship and conservatorship and that legal finding of incapacity mean that any contract they enter into is void. Never existed because the person didn't have capacity. Let me give you a real world example. We're seeing a tremendous amount of fraud against special needs individuals. When I list preferences for folks with special needs that I know are going to wind up in the public arena, wills that are going to be recorded in the book of wills that are publicly searchable, I never include the individual's name because we're seeing a tremendous amount of fraud. People are trying to get social security numbers to take out loans, credit cards, contracts in the name of that special needs individual because they think no one's watching. If we have a guardianship or conservatorship, we have a court declaration of incapacity. If our loved one never had the authority to enter into that contract, it's void. I get to call the car dealership. I get to call the bank. I get to call the whoever. You didn't do your due diligence. This individual had no authority to enter into the contract. Now, I worry about somebody getting a social security number and doing this. I worry about people in my special needs individual's life taking advantage of them, trying to get them in person to take out a loan, to buy a car, to do things that benefit. This, I can't think of a nice, appropriate term to use for a public recording. This bad actor, let's just go with bad actor. If a bad actor, if your loved one is prone to a bad actor influencing them, guardianship and conservatorship may be your best route. Remember, we talked about how powers of attorney are permissive. Guardianship and conservatorship is mandatory. Your word goes. Now, the law tells us that we are supposed to be involved. We are supposed to involve our special needs individual in the decision-making. But what guardian and conservator says goes. So, permissive powers of attorney, mandatory guardianship and conservatorship. With that power of attorney, I have legal capacity. I can give my agency, my free agency to my agent to act on my behalf. Guardianship and conservatorship, I am legally incapacitated. I am foreclosed from giving that power because the court says I can't. Only my guardian and conservator can act for me. So when we're looking at using these two documents, which one is best, I have to consider vulnerability. If there's a good chance that my loved one with special needs is going to be taken advantage of, we can give powers of attorney a try with that huge warning sign, permissive, not mandatory. If my loved one is taken advantage of and they execute a contract, I can try to get out of it. I can work my darndest to pull them out of it and remove that obligation so they are not found to be in breach. But the law feels that person is capacitated. The law presumes legal capacity until it's taken away in a guardianship and conservatorship proceeding. So I promised I would define those terms. Let's go back to guardianship and conservatorship land and define the terms. Guardianship, it is the ability, to make medical and personal decisions on behalf of my loved one. Conservatorship, I'm managing the money. So two separate roles. And Virginia separates them out very intentionally because you may not need both. Oftentimes, our goal is to just do guardianship, not conservatorship. We need somebody who's going to be able to have an ongoing authority to make medical and personal decisions. Guardianship. Conservatorship is the ability to manage money. Now, if I've got a new 18-year-old, which frankly is most of the people probably watching this workshop, if you're still with me, if you can still stand the sound of my voice, if it's a new 18-year-old, chances are there isn't money to manage. And it's our goal not to have money in the name of that special needs individual. But if I'm not going to dive into all the qualifications, but Virginia law does make several exceptions where even if this person has money in their own name, we don't need a conservator. That's why whenever you sit down with a lawyer to talk about this, please make sure it's an individual with a background in special needs who will understand all of this. If you go to a general practitioner, you run the risk they won't understand these intricacies. I can't tell you the number of times I see a guardian and conservator appointed for an individual with special needs, and they didn't need the conservatorship. So it's very, very important to make sure we only get what we need, because once we're there, we're there. The guardianship reporting is not that difficult. There were some changes in the statute governing this that do require more formal reporting and on a more regular basis. Still not as arduous as the reporting for the conservatorship. If you're managing someone else's money and the judge has given you the authority to do this, you best believe the judge and the court want to make 100% sure you're not going to do anything funny with the money. And how are they going to verify that? They're going to verify that with an inventory where you list all the assets you manage on behalf of your loved one, and then regular countings where you let the commissioner of accounts, and I'm going to define that in a second, you let the commissioner of accounts know everything happening with the money for your loved one. I joke, except it's not a joke, it's true. The IRS lets you round to the nearest dollar. The commissioner of accounts is going to make you account to the penny with what you've done with the money on behalf of your loved one. Commissioner of accounts is a quasi-judicial officer whose sole job it is to, when I say quasi-judicial, there's a commissioner of accounts for each county in Virginia, appointed by the local circuit court. Their job is to supervise the administration of estates, conservatorships, wills, trusts that somehow wound up reporting here. That's a whole other workshop. I'm not going to cover that. But the commissioner of accounts' job is to supervise the administration of these estates. And the commissioner of accounts' job is a noble one. It's to make sure people don't steal, but we make sure they don't steal by accounting down to the penny for everything they've done. When we need this accounting, when we need this supervision, it's very, very important. But we don't want to get it if we don't need it. And that's a distinction I find isn't drawn enough. Do we need this? If you're looking at guardianship and conservatorship for your loved one, sit down with a special needs attorney, an elder law attorney, if that's the realm your loved one is in, to understand, can we do powers of attorney? Do they already have powers of attorney? Are these valid? Will they get the job done? Before we go down guardianship and conservatorship route, because that accounting is a lot of work, and I'm using accounting in the general sense. For those of you who've had some exposure, you know you file your initial inventory and then your regular accountings with everything that's happening. I'm using accounting as a verb right now. Accounting to the court for everything you've done with the money. I don't know anybody who enjoys this process because it is so arduous. Now, again, if we need it, it's important to get the conservatorship so there is somebody to manage the money. But before we walk down that pike, I want to make real sure we need it. Now, we've defined the terms. We understand we can't have one without the other. We understand the removal of that legal capacity, the removal of rights, the removal of rights. That's a big thing we don't focus on enough. If we're walking down this path of guardianship and or conservatorship, we're removing somebody's rights. And we're also reporting, accounting, swearing to the court that the guardianship and the conservatorship is the least restrictive alternative. Jen, what the heck does that mean? Well, now we're going to tie back to powers of attorney and why I tackled sharing all this information with you in kind of a circumspect way. When we account to the court, when we file the petition with the court saying we need guardianship and conservatorship, we are also attesting, we are swearing that the least restrictive alternative, powers of attorney, won't work, won't get the job done. For individuals who've never had one, we are attesting they don't have the capacity. And I need to be 100% sure they don't have the capacity before I'm going to swear to the court, least restrictive alternative is not viable. I'm here in front of you, Judge, because there is no other way to make sure that my loved one with special needs is getting the protection that they need. We all need somebody to help us with decisions. If it's initial powers of attorney, I need to be able to report to the court. They don't have the capacity to do it. We tried. I talked to the doctor. I sometimes will meet with the individual. I'm always very hesitant to meet with the special needs individual off the bat, because once I've met with them, I have personal and confidential information about them. And if there does need to be a guardianship and conservatorship proceeding, because I now have confidential information about that loved one with special needs, I'm most likely referring the case out. Why? It's an adversarial proceeding. And when we look at the rules that govern lawyers and conflicts, I read those very, very, very strictly. I can't bring a proceeding against a loved one when I have confidential information about them. Now, that's something you're going to find lawyers have different opinions on. But if you hear somebody who's routinely in this field say, hang on, don't bring Johnny in to meet with me just yet. I'm going to get that capacity evaluation completed first. Your loved one has turned 18. We are trying to suss out which path to take. I need that evaluation first to let the doctor's going to give me an indication which way I can go. If that doctor's evaluation comes back, Johnny, I always call my loved one Johnny, Johnny's got capacity, in my opinion. Great. Then I, lawyer, will meet with Johnny. Now, it's very possible I could meet with Johnny and say, I am so sorry. I know the doctor said this. From a legal capacity standpoint, I don't think Johnny's there. I cannot in good conscience move forward. Here are the names of 3 of my colleagues in Northern Virginia to seek for a guardianship conservatorship proceeding. Because remember, when I'm filing that petition, I have to say, I've ruled everything else out. I can't get to guardianship and conservatorship unless I'm really, really sure this is what we need. And that's why all of these are tools in our toolkit, and why it's not always 100% clear which tool we need. And that's why it's so important to work with a lawyer who understands what the tools are and understands how they can be utilized. Now, I ran off the road a little bit talking about conflicts and confidential information. What's important to take away about that is what these proceedings are. The fact that it's litigation that can starts as uncontested, as long as no one is fighting this, and it can become contested if it becomes an adversarial proceeding where the respondent, the person alleged to be incapacitated, says, I don't want this. The reason you see me pausing and you see the weight that this carries for me is because these are not rubber stamped petitions. And before we get to the point of removing somebody's legal rights, declaring them legally incapacitated, moving forward with this court reporting, I have to make sure that my powers of attorney were not a viable option. Now, that doesn't mean that guardianship and conservatorship are the devil. There's going to be times we need them. There's going to be times where there's absolutely no other option because my individual didn't have capacity, or the powers of attorney do not adequately protect my individual. I've got to be able to protect them. I have to be able to stop bad actors. If that power of attorney is prone to being revoked, which it is, if my individual is prone to giving away money and there's no way to stop it, I need that. Now, I've geared my talk much more towards tools in the capacity toolkit for minors turning 18, for our members of the elder community who are wrestling with a dementia diagnosis. For whatever reason, it's a much different trajectory. The concepts are all still the same, but we wrestle a lot more with, do I need guardianship and conservatorship to protect them from bad decisions? You know, one of the things I always tell clients is the law doesn't protect us from making bad decisions. The law steps in to protect us when we lack capacity and are therefore making bad decisions. If someone is completely capacitated, they know exactly what's going on around them, they decide to give all their money away and live on the street, that's their choice. What we have to be sure of is when we're talking about capacity, we make sure that there is requisite capacity to make decisions that are in our own best interest. Not enough conversation happens about powers of attorney. And the risk I run in I want to say hawking them, is they are not a cure-all. They are not a be-all, they are not an end-all. And they don't always, it's not always our stopping point, but it should be our starting point. At least the discussion. Can this individual enter into powers of attorney? Because the call I get, my son has XYZ diagnosis, we need guardianship. Pull back on the reins for a second. Talk to me about that diagnosis. I want to talk to the doctor. I want to make sure that the requisite capacity is not there to execute the financial and the medical power of attorney before I run to guardianship and conservatorship. Now, what if it's not there? Yeah, we're going guardianship and conservatorship. It's a useful tool to have in the toolkit, but if you don't know what your options are, how are you going to suss out which one you should take? Now, one question, the only part I don't like about pre-recording is I love interacting with the audience. So I'm going to guess at a couple of the questions most of you have and try to answer them. Hopefully this has given you, this was intended as a 30,000 foot overview. Powers of attorney, when they can be utilized, guardianship and conservatorship, when it could be utilized, the interplay between them. They are connected. The capacity conversation connects them. So you've got a loved one turning 18, and remember, that's been my focus here. I could talk for days and days and days, probably months and months and months about all of the nuances. But my guess is, as we talk about having these tools, we're talking a lot about an individual turning 18. We're talking a lot about individuals who've never done planning before, but do have a diagnosis that may impede their capacity. So one question I think a lot of you have is, Jen, how do I find a lawyer? Because I get that question at every single seminar that I do. When you're looking for a special needs attorney, please do not just pick the person who's closest to you geographically. You want to call 3 lawyers. You want to have looked at their bios, sussed them out a little bit to make sure this is actually an area that they practice in routinely. If they are a general practitioner, that doesn't mean they don't practice in this routinely, but it may mean they're less familiar with the subtleties, the nuances. Those are the cases I see where we get guardianship and conservatorship when we don't need conservatorship, because there was some subsection of the statute that lawyer was unfamiliar with. And so now we're in the position of having to change the trajectory of what already happened. You want a lawyer who routinely practices in this area. If the lawyer, not the lawyer's assistant or paralegal, if the lawyer will not talk to you for free for 10 to 15 minutes to figure out if this is a good fit, you don't want them. I'm going to say it again. If the lawyer will not talk to you for free for 10 to 15 minutes, you don't want them. Now, we're not going to do a consult for free necessarily, and that 10 to 15 call can't stretch into an hour because we're serving clients everywhere. But you need to make sure it's a good fit. Special needs planning is an incredibly intimate thing. You are a part of your lawyer's life and vice versa, if it's a good fit, for a very, very long time. Jan hears me say all the time, special needs families are ride or die. Once you're in with them, you're in with them, and you are the person they turn to in times of crisis. And the reason the ARC and I are working together to offer this series is because special needs planning does not happen in a vacuum. There's the estate planning component for mom and dad to make sure anything they leave for their loved one doesn't violate their public benefits. Sometimes there's estate planning for the special needs individual to protect money they already have so they can maintain or qualify for public benefits. Then there's the capacity question, which is what we're talking about today. How do we make sure there's a decision maker in place who can assist our loved one with special needs? That's that component. Third component is benefits, making sure our beneficiary, our special needs loved one, qualifies for everything they are eligible to qualify for. It's not just, are they getting benefits now? What benefits could they be getting? That's the benefits conversation. And the last prong of this four-pronged plan is the toughest. I don't have a good name for it. So if you think of a good name, please let me know. Transition planning. How is our loved one going to be cared for if we're not there? And that capacity conversation is integral to making sure our loved one has a transition plan for when we're not here. Who's going to be the decision maker when you're not with us anymore? That's that part of the conversation. Any lawyer worth his or her salt is going to talk about a backup agent if it's a power of attorney. Who's going to serve in case you can't serve? Who's going to make sure Johnny has somebody? If it's a guardianship and conservatorship petition, it's making sure there's a younger co-guardian appointed with you to serve. So when you're no longer with us, we've got a decision maker. Standby guardianship, conservatorship, also important, does have a few caveats to it, but the end game is making sure, as part of our transition plan, we have continuity of capacity care. Continuity. The plan has to still work. So when you're calling attorneys to find out who is a good fit, you have to make sure you like the person. It's an intimate relationship that can span years. Oftentimes, the lawyer is the only person in that continuing role to make sure your loved one, that plan executes flawlessly. So if that lawyer won't talk to you for free for 10 to 15 minutes to see if it's a good fit, I wouldn't want to use them. Then you want to make sure you ask up front, what is your fee structure? How do you bill? Lawyers are humans. We make mistakes. It's important to ask the question. When I say we're human, we make mistakes. Sometimes we shoot out an email, forgets to mention what that hourly rate is. You want to make sure you ask, what am I getting into? Is that first consult billed? If so, what is your rate? Do you cap the time for the initial consult? How do you bill? I always tell folks who just, want to exchange emails and not have this conversation, I'm an expensive friend to have. You want to know exactly how much you're getting into with this lawyer. Verify experience, verify you like the person, verify the billing structure. If you need comprehensive planning, ask how that plan is going to bill every single step of the way, because it matters. When you select an attorney, make sure they do this. Make sure they know what they're doing, because a lot of times this planning, if done incorrectly, is very, very expensive to be undone. Next question, I'm guessing somebody has. Jen, I'm just going to run these off. While you were talking, I climbed on Google and I found statutory powers of attorney, or I found free powers of attorney published someplace. Just going to run these out. I cannot advise strongly enough against doing that. And here's why. When these powers of attorney are questioned, they will be questioned. It's important to have a bar license behind them. One of the things I routinely do when powers of attorney are not accepted is I complete an affidavit where I vouch for the power of attorney. And I say it was validly executed with me. The principal, the person who signed it, is my client. He was fully capacitated at the time he signed it. He knew what he was doing. Because this individual is my client, I can vouch for the fact that the power of attorney has not been revoked. It is still in full force and effect. And I sign this, I swear it as an affidavit, and I submit it. Now, basically, the bank wants to ride on my bar license. So if the power of attorney turns out to be bum, they get to turn around and point the finger at me and say, nope, Jen vouched for it. That's the only reason we accepted it. They want to ride on my bar license. They want to ride on my malpractice insurance. I'm only going to do that. I'm only going to submit something so powerful as that type of affidavit if it's my client, and I can truly vouch for all of those things. There's a fun little facet of the Uniform Power of Attorney Act. When these documents are refused, and it happens, and I do that affidavit, which should be all they need, if the bank still refuses to take it, I get to tell the bank, guess what? Under the Uniform Power of Attorney Act, I'm going to bring a proceeding to force you to accept this. We've ticked every box. We've done everything you've asked for us. My time is billable to you, big bank. You have to pay for all of my time to get this accepted. Where would you like me to send my invoice? I bill out at X number of dollars. Here's how much time I anticipate using for this. Oh, and by the way, I have a different court hourly rate. You'd be shocked at how often that email suddenly shakes everything loose. Oh my goodness, Mrs. Crane, we talked to our legal department and they've decided to accept the power of attorney. If you don't work with an attorney, most attorneys will not do that affidavit for you, your agent trying to get your principal's power of attorney accepted, unless it's my power of attorney. I'm not going to go to bat for somebody else's document. Definitely not going to go to bat for something that was pulled off the internet. It's important to meet with a lawyer who can help you make sure the document is valid and make sure we meet that requisite component of capacity. Because if the individual can't understand what they're signing, if they can't understand the authority to give you this power, you don't want it. You may think it's the quicker, easier route, so we'll just execute it super fast. I guarantee you it's going to run into problems. We have to meet our special needs loved ones where they're at. Part of that is recognizing their capacity, working with them to pick the avenue that suits them best. If I'm going to run down guardianship and conservatorship avenue, I need to make 100% sure power of attorney avenue is blockaded. For whatever reason, it won't work. Two powerful tools, they can sometimes kind of work in conjunction with another, a whole other workshop there. But I want to make sure these components are addressed. I want to make sure you have tools in your toolkit to advocate for your loved one. As I mentioned to you, when Joe was born, I was fortunate. I already had the tools in my toolkit, and I found I've been able to utilize them frequently. My firm administrator at Odin Feldman Piddleman loves this story. When Joe was first sick and we're in and out of the hospital and we're meeting teams of people and I'm filling out, as all of you special needs parents know, paperwork. I felt like I had my own clipboard, used to carry my own pens to fill everything out. I used to write under my occupation, mother. I did that for about 2 visits. And then by the 3rd, I started writing attorney as my occupation and stapling my business card to the paperwork. And I shockingly found that I was treated with a heck of a lot more respect. My requests were given much more weight. I was treated differently. It's a sad commentary on the system that serves our loved ones, but it's unfortunately true. And my goal in offering these webinars is to make sure you have tools so you don't feel talked at, you have conversations with. I want you to understand what your rights are. I want you to understand, I want to help understand what services are available, what tools are available as we embark on this incredibly important task of serving our loved ones, because it does change when they turn 18. We have to start having these conversations. At around 17 and a half, you can file the petition for guardianship and conservatorship. And unfortunately, I see a lot of families run to that because they can get it quicker. Powers of attorney, we have to wait till they're 18. No reason we can't start having the conversations before 18 and executing those powers of attorney on the 18th birthday, if that's the path we choose. But you have options. It's not just guardianship and conservatorship. You have options for powers of attorney. Your loved one has these options. Explore them. Meet with somebody who will lay all of this out for you in the trajectory of that entire plan that you need. None of this happens in a vacuum. Use the tools in your toolkit to decide, how is my loved one best served? Understand the intricacies. Take time to make those decisions. Sometimes time is not on our side and there's an emergency and we need to get something done right away. That's why we want to plan in advance. So remember, stress and grief don't do good things to us. We don't want to make decisions in a vacuum filled with stress and grief. We want to make decisions when we have the luxury of time to consider what our options are, make sure we are fully informed. Knowledge is power. Ask questions, get resources. I'm very hesitant to tell people to get on the web. ARC is a great source, a trusted source. Special Needs Alliance is a trusted source. Academy of Special Needs Planners is a trusted source. I would advise against, please don't just get on somebody's blog because we can't verify the information. We can't make sure that the information you're receiving is valid. You know, when I was, as I mentioned, a mom of 5, pregnant with my twins, identical twins, my OB and I made a deal. He wasn't going to tell me about any of the bad stuff that could happen, and I wasn't going to get on Google and look anything up. I stole that line, and that's what I tell my clients now. Please don't get on Google. If you have questions, come to me so I can answer them and make sure you're getting correct information. If you hire a lawyer, work with the lawyer, make sure it's a partnership. That's why I want you to vet them. Make sure it's somebody you feel comfortable adding to your team. The trajectory for our special needs loved ones is long and ever changing. We need to make sure we have players on our team who are truly involved for the right reasons that we feel comfortable with. I am grateful to you for gutting out the sound of my voice for over an hour as we talk about all of these tools. This, as I mentioned, was your 30,000 foot overview. Tools in the Capacity Toolkit, powers of attorney, guardianship and conservatorship. If you have questions, please feel free to reach out. I'm always happy to answer questions. Contact an attorney in your area. Make sure they're a special needs attorney. Make sure this is what they do. Make sure you feel empowered to make decisions on behalf of your loved one. On behalf of Odin Feldman Piddleman in Reston, I'm Jen Crane. Delighted to have been with you this morning. Many thanks to the ARC of Prince William for hosting me, in particular, Jan Russell. Thank you for this opportunity to spend time with you, to be with you, and to share information on tools in our Capacity Toolkit.